So hello and welcome friends to the knowledge sharing series powered by Shoolini University School of Law. Today in this second part we have another legal luminary with us. I have with me Mr. Essenese Obhan, the managing partner of Obhan and Associates based in New Delhi. Just a brief introduction before I welcome Mr. Obhan here. So Essenese Obhan is the managing partner at Obhan and Associates, and Mr. Obhan, I'm told, is an IP lawyer, patent agent, and has a degree in mechanical engineering. That sounds a bit interesting here. While he has drafted and prosecuted and litigated cases in mechanical, civil, pharmaceutical, and software, telecommunications, agricultural sectors also. He also has been in forefront of several high-stake IP licensing and litigation matters in India. Particularly, we can have the example of the Indian seed industry. So, with the licensing dispute concerning the genetically modified seeds, as well as various Indian mobile manufacturers in their SEP discussions with SEP owners. He's also advisory here. He advises many of the companies, the Fortune 500 based companies and leading businesses on developing and maintaining their patent portfolios and IP strategies and licensing. So I welcome you, sir, on the board today here.
Thank you.
So the idea just came about 2 weeks earlier in my mind that we should have something virtually the knowledge sharing process so that all these uh, basic disputes pertaining to litigations or be it fundamental rights, right to health or any pandemic related issues, we should share it and bring it to the students for the benefit of the students. So this is how we begin, and the first in this series was by Professor Sebastian Lafrance, and we have today the another luminary here in front of all of us. So I welcome you, sir, on the board. So before starting, and the theme basically today will be based, as I'm told that he's a IP lawyer, a top IP lawyer of the country also, along with the managing partner. The theme basically will revolve around patents, issue, a problem which has taken the forefront in India for quite a long now, a decade, I can say, just when the internationalization of the patent started, right from 1995 onwards, and then the 2005 post-amendment changes that came to the law. So we will be revolving around that, but yes, we will be giving a legal perspective to it. And also, most interestingly, as soon as I may tell you here, that Shoolini, also based here in Solan, is a front runner in patent filing. So we have approximately about 415 patents filed till date, and latest figure as told by Vice Chancellor Shoolini University, Professor P.K. Khosla, we have approximately about 25 patents which have been granted also, and the same number is under process. It's in pipeline of being granted soon. So yes, it becomes more, the talk becomes very, very important for all the engineers of Shoolini, the patent filers of Shoolini, because we are aggressively into that mode of patent litigation and patent filing and all the patent prosecution, most importantly, that a common man or a common scientist even should know that how a patent is filed, what are the intricacies in that, and later on how to sustain that patent, how to keep it alive. That is most important. So just going, before going to the theme, I would just, my first question will be again after your intro also. Still, I'm interested that how you began all this, how has your journey, your past 1 decade journey in patents been through?
How I began all this, actually, that was almost 2 decades ago. I'd finished engineering, and the options at that time for an engineer was, more like a traditional engineering role, or you went and did your masters in some field, and uh, both of them weren't really exciting for me. And my introduction to IP actually was a chance introduction, and it was with a friend of mine, and we were in Pune, and just over some drinks and dinner, and he was like, "Listen, why don't you come join IP?" And I didn't even know that that was an option as such for the scientific community to even explore as a possibility. And bus, one thing led to another, and I started, and then realized I needed to pursue law. Then got registered as a patent agent. And initially, the early years was actually really focused more on patent drafting, patent prosecution. But the last 5 to 8 years has really been focused more on uh, IP strategy, IP litigation, portfolio management. How do you monetize your portfolio? How do you structure your portfolio? Where does the value really lie? That's been my focus, Nandan, these last 5, 7 years.
Okay, so as I told you that, how do you feel that how did this patent journey, the legal journey began, and how far was the Patent Amendment Act of 2000, 1999, 2002, and 2005 important in shaping the IP strategy of India?
Well, you see, the 2002 amendment, to my mind, was a fairly significant amendment. The So, like you mentioned earlier, like '95, we decided to become a part of the whole WIPO process. By '97, '98, we had signed on to the PCT, and in those days, the when I started the profession, the total number of filings in India was less than 5,000. In fact, it was more like 3,000 or 4,000 patent applications in the country,
Okay.
and of which the Indian filings were less than 500. And so most of the filings that were taking place were coming from overseas. The IP and patent as a profession was not that big as a segment. The accession, I feel, to the WIPO, the PCT, saw a steady rise in numbers. And so for the last couple of years, I would say the numbers have been over 40,000 plus, with the Indian participation in that also at, I'm guessing right now, I don't have the numbers before me, but at last count, I know that the Indian filings were over 7 to 8,000 of that 40,000. So you see, percentage wise, overall volume wise, Indian filings have really gone up. They continue to rise. And in terms of awareness, the the notion that patent rights play a role in business, in society, that awareness has really come up now. And I think all of us are aware that there are patent issues around stuff. This is as opposed to years ago when we used to go for client training sessions. We would There was also that whole question of what is the difference between a trademark and a patent. You know, you don't get those questions today, but it's been a long journey. I think it's been a long journey.
So, according to you, what is the share of the PCT applications along with that? So, how do you balance? How have the Indian companies balanced? Are they going more towards filing of a Indian patent, or they are taking the PCT route?
So for Indian companies, actually, it's difficult to answer that because it's not different companies use a different strategy,
Okay.
and you have to keep in mind that while filing in India is relatively cheap,
Yes.
filing overseas is very expensive, right? So especially if you go to jurisdictions that where filing is not in English, the cost of filing, just the cost of filing in say Japan or China, can be lakhs. And then your prosecution starts, and then you engage your attorneys there, and you will argue the case before those officers. So, I mean, I used to say on an average, you should consider that for one invention, if you were to go into, say, approximately 20 major jurisdictions, you should budget $1 million, because you will need that to, file, prosecute, and potentially even do some sort of maintenance initial annual. About $1 million a patent is a good number to work with.
Okay. So, how far has the litigation matter gone ahead now? How are the companies now more aware about the sustaining their patents and going for litigations, or for conserving their patents? What is the legal scenario today as far as the apex courts or the higher courts of some major uh, metropolitan cities are concerned?
So again, the answer would depend organization to organization. Each company has a different perspective on things, and you have to keep in mind that ultimately a patent is a contract between you as an inventor or as an applicant and the government. You get into a contract, right? Now, what is that contract? That contract says you as an inventor disclose everything. What is it that you have done? What's that improvement? How does it work? What's the best way of working it? And you disclose all of that. In return, the government gives you a 20-year monopoly, right? Now, and what is that monopoly that you get is also very important to keep in mind. It's not the right to use your invention. A patent is a negative right. It is the right to exclude others from using your invention. Right? So just because you've created something, say you improve on a process or you improve upon an existing device or the product, you come up with an improvement over it, and you file your patent for that improvement. You'll get a patent for that improvement. But does that necessarily give you the right to use your own invention? No, right? It doesn't necessarily give you that right because a patent is only a negative right. Now, let me give you an example of that. Assuming that there was a pen, right? A pen is known, and Nandan, you invent a rubber grip for that pen, just so that while on long usage, your thumb and your forefinger don't go sore. You invent that rubber grip, and you get a patent for the rubber grip for the pen, right? But the underlying patent on the pen is mine. If that's the case, are you allowed, now that you have a patent on the rubber grip, can you start selling pens with rubber grips? You can't. Because the minute you do that, you're going to end up infringing my underlying pen patent. And so that's how the whole ecosystem works, right? You have to keep in mind that ultimately what you're getting are rights to stop others from using. And so I'm just giving you this background to answer your question in terms of how do companies approach this? Now, there are some companies who would take a view and say, I just want a patent for exactly what I've done, and I don't want to get too much into strategy. And that's fine. I mean, that's a good starting point. But then there are organizations that will say, hang on, where is this technology likely to go 5-7 years from today? Right? What are my competitors likely to do in this space? And what do I plan to do? Do I plan to launch this product? So for example, if Shoolini University has 25 granted patents, what's the end goal? What's the end goal, right? So if you want to eventually license this or monetize this, then the way you draft those patents, the way you structure those patents will perhaps be different, right? So you'll look at a particular technology area and you'll say, in this particular area, have I done my landscape? These are the existing patents. These are who my competitors are. These are the kind of patents they have. I find a gap in this technology area. Let me focus my research in that gap. Let me get patents in that gap. And now you're in a strategic position to go and discuss this with other companies and say, you know what, in this particular technology area, we notice you're doing this product. If you license our portfolio, we're able to give you a whole basket of IP that will help you come up with the next generation product. And that basket is important, Nandan, because if you come up to someone and say, I have one patent, license it, and give me money, chances of you succeeding are very low. Simply because it very rarely works as a one patent, technology. It really very rarely works like that, right? So even for a company to launch, they will need to see, okay, I'm getting this one patent from you. What are the other patents around it? What are the other patents underlying it? Can I launch? Can I not launch? So, like I said, it really depends on who the company is, what their strategy is, and how they've structured their portfolio on whether or not they will go offensive or not.
So I see that as an inventor, that means I need to create a whole solution, a whole basket, or I have an idea in my mind, I start materializing on it, and I have a dream that yes, I want a patent on it. It might not be a particular whole basket. So how should I take my strategy forward?
So, there are many cases where a single patent is good enough for an individual inventor,
Okay.
right? But when you're looking at organizations that are, spending a certain amount of their budgets on R&D and are getting 400 to 500 patents a year or more, then those are not random, right? So there, the way the process works is that each inventor will submit his form that this is my invention. There's an invention board or like a review committee that will check those inventions. They'll say, okay, is it fitting in this our existing products? Is it towards future products?
Yes.
If it's for existing products, uh, you know, is it really likely to hit the market? Is it something that we can launch immediately? Is it something that we're not likely to launch? Is it something that I can use to block my competitor? Various factors are looked at, and then that patent disclosure is kind of classified, and then the organization kind of goes ahead and files it in a larger budgetary perspective. So that's where I meant with my basket example. But on the other hand, and I can give you a very good case for this, there was this individual inventor, a professor in fact, from Bangalore. He's I think he's a national awardee as well, and Vardhana Nayak. Now he came up with a very simple innovation on a razor blade. And what he said was, let's see, in any shaving system, there are two blades. And what happens is when I'm shaving, hair gets stuck between those two blades. So my innovation is that I will put some holes on the lower blade, but not just the holes on the blade are known, but my holes will be such that half the hole will be exposed and half the hole will be covered by the top blade, right? So you have an upper blade, you have a lower blade. On the lower blade, there are holes, and those holes are positioned in such a way that half that hole is covered by the top blade. Now, he files this patent. There is an opposition by Gillette before the Indian Patent Office, and he succeeds in getting that. He still gets his patent. He succeeds. So Gillette, nicely walks away
Yes.
and says, okay, we will not go ahead with this. But he then writes to these other Indian manufacturers, and I won't name them here, it's an ongoing matter. He writes to these other manufacturers and says, would you like to kind of take my technology? And they said, no, no, we're not really interested. And he finds 5-10 years later that actually that whole range of those blades has that hole positioned exactly the way I had said they would be positioned. Now, if you notice the old Gillette razors, they did not, they had the hole, but they would not position it in that manner. Whereas this other Indian manufacturer had moved the hole and positioned it in that way. So this guy rightfully went to court, and he went to court on the basis of one patent. So that's fine. There are certain technologies where one patent is good enough for you. But in that case, and this is a requirement kind of unique to India, what the court said is that, look, Mr. Individual Inventor, you are not working your patent, right? So this company is working its patent. So at an interim stage, why should we stop somebody who's actually working it? He's saying your patent is invalid. According to us, he's raising a challenge on the validity of your patent. It may be a credible challenge. And you are in any case not working it. If you succeed, he will pay you, right?
Okay.
And so we don't need to injunct him today. You see, that principle is very unique to Indian law. That if you are not working your invention, then you may not get interim relief. If you succeed in trial, you might get damages and accounts, but this interim relief becomes very difficult for an individual inventor if he's not personally working it himself.
That means the working of invention becomes the quid pro quo here.
Yes, it's there
Yes.
in our act.
It's there in that. Yes, that's right.
The act says that patents are granted not just for merely importation,
Yes.
and there is the general principles state that is to work the patent. In fact, which is why we have a provision that says that 3 years from the date of grant of a patent, if you're not working it, Any person can apply for the compulsory license.
Yes, exactly. So that sounds interesting. That these are the inbuilt small stories behind each and every patent. I guess that makes it very, very interesting.
Right.
So I would proceed further. So as the patent rights become more important, what can we do to ensure good patent protection, according to you?
So I would say getting your a good strategy in place is very important nowadays. It's no longer okay to just randomly file patents and collect like a bouquet of patents which may or may not speak to each other. You see, uh, about 20 odd years ago, the general notion of patents was let's try and get broad claims, as broad as possible, right? Because with broad claims, we will cover so much more that any possible infringement will fall within the scope of my patent. That's really not how it works today, right? So you would rather, you would rather get a small patent, but a strong patent, right? Now, ultimately, what is a patent? You're drawing a boundary and you're saying, this is my land. If you step into my land, you infringe and you have to pay me.
Yeah.
Now, therefore, logically, if you had to make a fence on your land, if it was a big fence, that means it's that much more difficult for you to protect that bigger boundary, right? But if it's a smaller fence, chances are you'll be able to secure that fence in a better way. And what are the attacks on the fence? Prior art. So if you have claimed a really broad kind of invention, chances are that much more prior art will be used against you. Whereas if you asked for something very small, very specific, very difficult to get prior art to challenge it. So you've got less, but you've got something strong. And that's where strategy comes in. Because ultimately today, a good organization will build a portfolio of 5 or 10 small patents, which by themselves cover very little, but collectively block a good space, a good tech space, right? So having a good strategy in place is important. B, I would say managing your invention disclosures within your organization, how you, what is the process that you follow? Are the inventors comfortable knowing what they have to put into the form? What's the next step? What's the requirement? It shouldn't happen that an inventor comes up to management and or to whatever his boss or his tech boss and submits an invention disclosure, and the manager sits on that invention disclosure for 6 months, right? So you demotivate, you kill the system within your organization. So having those kind of processes, having a good strategy, in my view, those are the things uh, which ultimately go towards making a good patent. Keeping in mind that ultimately it's a contract. So if you end up not disclosing enough, or if you end up not giving enough, examples in support of your invention, there's it's liable to come under attack for insufficiency. There's no basis for this claim.